Hello everyone, welcome back to the video updates. It's Sade. Today's video is going to discuss the homeowners association liens when we compare them to the mortgage liens that are attached to real estate. And when I'm talking about the mortgage liens in this particular video, I will specifically be talking about the purchase money mortgages. So the loans that people take out for purposes of actually purchasing the property as opposed to a home equity loan or some other type of loan that they take out after the fact. So what exactly is a lien anyway? So the simplest way that I can think about it is to summarize it as an indebtedness that attaches to specific property, whether it's personal property or real property, to secure future payment of that indebtedness. And so the lien sometimes will be created voluntarily in the sense that maybe I approach the lender because I found this beautiful home that I would like to purchase, and I approach them to ask for a loan. In that case, I will sign documents promising to pay back the mortgage, and that is voluntarily created. Things like judgment liens, on the other hand, and even the HOA liens, they're not voluntarily created, they're involuntary types because they are forced on me after I stop making payments on my homeowners association assessments, or sometimes when a judgment creditor wins a lawsuit against me and they get a judgment and file it into the property records, then they could have a lien that's attaching itself to my real estate. And then let's talk about the homeowners associations specifically because they're very unique types of associations. And the homeowners associations have a bad rep out there because they get on a lot of people's nerves. Let's be honest. And that's because most people think that they either arbitrarily enforce rules, or that they enforce stupid rules, or that they actually pick and choose whom to enforce against, meaning that they place some sort of favoritism when it comes to selecting which homeowners they're going to fine and which ones they're going to just overlook, any transgressions. So anyway, so how did they come about anyway? The HOAs have been there since the beginning of time, from what I understand, and the laws out there in every single state actually supports them. They're allowed to do things, generally speaking, because they're almost a private association of people. And it's a voluntary decision to buy a home that has an HOA governing the community. So the government says that they can do it because, hey, I could have bought my property somewhere else that doesn't have an HOA. And instead I chose this particular community. Therefore, I must submit to their rules. And so the documents that contain all of these rules, the documents are called CCRs, and that's covenants, conditions, and restrictions. And it does sound kind of weird, right? Because covenant, the last time I saw that word before law school was in the Bible, and it means promises. So the HOA is essentially saying, I promise to do A and B if you do A, B, C, D, E, F, G. So most of the promises in there are for the homeowners to actually perform, as opposed to the HOA performing those things. And then of course they have conditions. So the conditions upon which I can live there, or upon which I can own property there. And then of course the last word, restrictions. We all know what that means, and it's not really friendly sounding word, but they're essentially limiting what I can or cannot do with my property if I'm part of that community. And of course there are certain things that I might want to do. I don't agree with the HOA's rules, but the fact is I have to abide by those rules because the rules are already given to me at the beginning when I'm purchasing the property. Or if I was one of the very first homeowners to own in that area, then the developer would have given me those rules, because most of the time the CCRs are already in existence at the very onset when the developer starts envisioning what they want the community to be like. So most of them are the ones that create the CCRs because they might think, look, we have to have some governing rules to keep everybody in compliance with certain standards of presentation that we like the homes to have, with a certain look and feel that we like the area to have, or that we would like to have common areas that would add amenities to our community, but would like to be able to charge the homeowners for that benefit. So that's how the CCRs come about. Now that you know that, that is very important, because this brings me to the rule that I want to mention in this video. And this rule is a real estate rule that's pretty much the same in whatever state you're in. And the general rule started from the beginning of the beginning, right? So the rule says first in time is first in right. First in time is first in right. But as with anything else in law, every time you have a rule, you always have an exception to the rule, and then you have the exception to the exception, and so on and so forth. So that's why things get a little tricky or complicated once we're applying the rule or the law. So first in time is first in right. So the CCRs are typically a document, as we've already talked about, and you already are familiar with this document. And then the CCRs are filed into the property records to hold the position. So then they're first in time most of the time, not all of the time, but most of the time, because the CCRs are created at the beginning of that development. So the CCRs tend to be first in place because they're usually in existence at the very beginning of the development. And most homeowners don't start buying until later and then creating these other liens that we call the mortgage liens, right? They purchase the property with the help of a lender, and that creates that mortgage lien that I mentioned, which is also sometimes called the security interest, right? So that's what it is. The home is the collateral. And so now you have the HOA, who should be in first place. And then you also then have the mortgage lender, who would then be in second place if we follow our rule. Now there is an exception to that rule, which says that sometimes we agree to switch or we agree to replace. So then sometimes the HOAs will agree to take position number 2 in deference to the mortgage lenders, only for the purchase money lenders. And that's typically because they don't want to create an extraordinary hardship on the owners that are going to be living in that community, because most mortgage lenders do not like to be in position number 2, especially when it's a purchase money loan. So that's the actual loan that the person is using to purchase the property. Therefore, that's the collateral for that loan, and they deserve to be in first place. So most of the CCRs would have language in there saying that the HOA's lien is going to be superior to any other liens out there by virtue of the fact that they already had the CCRs saying so, and the CCRs are already on file with the county, but that their lien would not be superior to the mortgage liens that are created by the purchase money lender. So that particular clause is usually in the CCR. Sometimes it's not. So whenever it's in the CCR, then that means that mortgage lender goes to position 1 and HOA goes to position 2. And that's fine, because mortgage lenders prefer that. Occasionally you'll find out that that language is not in there. Therefore, the mortgage would then be a junior lien compared to the HOA's lien, okay? And then if you think about it in terms of super liens, those will be the ones that are created by the government agencies. And so, for instance, if I purchased that property in 2010 and the HOA was already in existence in 2005, then normally HOA will be number 1, and then my mortgage lender will be number 2. Let's say in 2020, IRS files a lien against me, which would then be filed into the property records as well, because they would like to seize my assets at some point. Then the IRS's lien is something that I would call a super lien, because it's going to jump over the other liens and become number 1. So that's how we talk about priorities of the lien holders or their liens. That's what lawyers mean when they're discussing this. And the priority rule of first in time, first in right doesn't always apply. And that's why, because there's some exceptions. So a government agency is an exception because theirs is always going to be number 1, no matter when it's filed. And then the HOAs also would normally be number 1, depending on when the CCR was filed. So I should have specified when I was talking about the HOA agreeing to put its own lien in second place, even though the CCRs were filed first. I should have explained that that particular thing is called a subordination. So that means that the HOA's lien is made to be subordinate to the mortgage lender's lien when the mortgage lender is the purchase money lender. So I wanted to clear that up really quickly. And that subordination also happens when the government liens are later filed, even though the CCRs were filed first, or maybe the mortgage lien was filed first, but the government files its lien much later, but yet it's able to subordinate the HOA's lien as well as the mortgage lien that's on that property. And that's a subordination as well, which is an exception to that first in time, first in right rule. So that term is called subordination, and it means that even though the first lien was first filed and therefore first in time and first in right, it has been subordinated to the later filed lien. And so the mortgage lender in that scenario, if the CCRs specify that the HOA's lien would be subordinated, then the mortgage lien would become first in right, even though it was not first in time. All right, so you've already learned everything there is to know. All right, so I think we're doing well with explaining all these different rules and the exceptions to rules. So what this means for you then is that you can't just know the general rule, because when it comes to law, things are rarely black and white. It's usually that you have to do deeper analysis and understand the full context and know all of the moving parts. So anytime you have questions about things that don't seem to make sense when you're trying to apply the general rule, it's because there's probably more to the story, or there's an exception that you don't know about. So I always suggest that you consult with a lawyer, and definitely a lawyer in your state or the state where that property is located, and then they'll be able to clear things up for you. Then the related question that we have to talk about in this video then is, what of those HOA foreclosures? What happens with the mortgage lien in that case? The question is a good question because the HOAs, as you know by now, have power to do a foreclosure based on unpaid assessments. So unpaid assessments are exactly what creates the HOA liens, and they actually are not required to physically file a document showing that they have a lien against property owners, because most of the time their CCRs would say, we don't have to file the document, it's automatically created once you're behind on your assessments that you were supposed to pay. So a lot of the HOAs have monthly assessments, some have quarterly assessments, and some have yearly assessments. And then they of course have some special assessments. And if you're already familiar, you know that the assessments are the monies that they collect every month or every quarter or every year to help maintain the community by cutting the grass in the common areas, maybe by maintaining a swimming pool and a playground for the kids. And so that's all from the pooled funds from all the assessments that people are paying. The special assessments, on the other hand, are used for special projects. Maybe the very first time they want to create that playground, they have to pay contractors a lot of money. So then they would charge a special assessment that's more than your normal assessments would be. So that's what the HOA does. And the only time they can do a foreclosure is if I, as the owner of the property, am behind on my assessment payments. They cannot do a foreclosure just because I parked my car on the wrong side, or I didn't take my trash can in and they fined me. The fines cannot cause a foreclosure, but they can cause you to rack up late fees and penalties. So that being said, the HOAs can definitely do a foreclosure, but they have to follow certain steps and give you notice after notice, and also give you the opportunity to cure the default. And then ultimately, even after all of that, they do have to go and file a lawsuit and get permission from the judge to be able to do a foreclosure. And all of that being said, they're supposed to also notify any other parties that have interest in that property. And that means they're supposed to notify your mortgage lender, obviously. The HOA is supposed to notify everybody else so that they know to protect their rights. And they don't always do it, but at the very minimum, they're supposed to notify the mortgage lender because that mortgage is already there. And most of the times, the mortgage liens will be priority one, so they will be senior to that HOA's lien that's about to foreclose. So then, of course, that leads us to the question of, well, I didn't know that the junior lien holders could actually do a foreclosure when the mortgage is still there. Yes, they can. So they can still go ahead and do a foreclosure, but we'll now discuss what happens to the mortgage in that case. Let's say that the HOA's lien is truly a junior lien to the mortgage lien that we discussed. Then the HOA will go through the foreclosure process normally. And then if the mortgage lender doesn't come to take care of those monies that I owe the HOA, then the HOA will get a judgment and go ahead and do the foreclosure. And of course, at that point, the third party buyer might bid at the auction and be able to purchase that property. Let's say I owe the HOA $10,000 on my assessments because I've missed a few years, and the third party buyer that wins at the auction ends up paying $25,000. That means that the HOA is going to collect $25,000 and give that physical property to the third party buyer. Of course, I might still be living inside the property, so the third party buyer would have to do an eviction and all that good stuff. So they'll get me out eventually. However, that means the collateral is now with the third party buyer and the HOA has $25,000. But then there's the mortgage lender still in the background, right? So the mortgage loan is still there. The property is now with somebody else, not me, and I was the borrower on that loan with the mortgage lender. So then the third party buyer in that case will be taking that collateral, the property, subject to my mortgage that I had, right? So they will take that property without any personal obligation to pay the mortgage. So the third party buyer does not have to pay it. However, the mortgage lender has the right to come back and take that collateral away by doing its own foreclosure. So they'll do a foreclosure and then the collateral will have to be turned back over to the mortgage lender. So that's how that would work when the mortgage lender is a senior lien holder. So in some scenarios, as you remember me saying, some mortgage liens are actually junior liens to the HOA liens. And then what happens in that case? When it's a junior lien to the HOA's lien, then the mortgage lenders are usually quickly going to pay the assessments that I owe to protect their interest, or they're going to quickly move to do their foreclosure first before the HOA does the foreclosure. And the reason is because in most states, whenever the HOA does the foreclosure, meaning that that HOA is senior in time and in right to all the other junior lien holders, then the junior liens are extinguished. They're not going to disappear, but they're extinguished from their attachment to that collateral. So the collateral is gone and the liens are separated from the collateral. However, the liens are still out there and those people can still come after me personally to try to satisfy the debts. Okay, so that's what happens when the mortgage lender is a junior lien holder. The collateral is gone. So it's never a good scenario for them. So they really don't allow that to happen. And remember, the HOA is going to notify the mortgage lender before being able to get to the point of doing an actual foreclosure. So the mortgage lender would step in and take care of things. Now, the related question that we get is what happens to the remaining money? Because the HOA got $25,000. I only owe them $10,000 at the time. So who gets the difference of $15,000 that the third party buyer paid at the auction? Well, it depends again. It depends again on whether they're junior lien holders or not. So let's say they're junior lien holders, whether they're judgment creditors, whether it's a child support lien, whether it's my mortgage lender that became a junior lien holder just because that's the way that everything worked out. Then all the junior lien holders have a chance to try to get the excess proceeds, because that $15,000 is actually considered as excess proceeds or surplus funds. So the junior lien holders can try to get it, I can try to get it, but the law says that the junior lien holders would have priority over me when it comes to the excess proceeds. Even though their liens have been extinguished, the debt still remains and they can try to get the excess proceeds to satisfy the debt. So this video is just a quick summary. I'm just skimming the top to give you an idea how weird these situations can get. And in fact, it's even worse because sometimes the answer is not clear based on the documents. It's not 100% clear whether the mortgage lender is a senior lien holder or a junior lien holder. And then guess what? The parties have to go and figure it out in front of a judge. They have to go to a hearing, argue their sides of the story, and present all the evidence. And then the lawyers would, of course, have to go through the documents, the CCRs, and also the mortgage security instrument, which would be the deed of trust or the trust deed, and maybe the note, and read through everything line by line to make sure that their documents support what they're trying to say. And of course, most times the mortgage lenders want to be in first place, so they usually argue that they are a senior lien holder as compared to the HOA, because that protects the collateral even if the HOA does the foreclosure. So hopefully you're all caught up now. Remember, first in time is first in right, except for where there's subordination, or except for where it's a government lien, in which case the government lien is always going to be first in place and in right. So I hope this video has been helpful to you. And if you have questions whenever you're trying to purchase property that's being sold by an HOA in a foreclosure auction, you should talk to the lawyer first before you bid, so that you as a third-party buyer can feel secure in knowing whether you're purchasing that property subject to the mortgage or not. And the way that most of the third-party buyers make money off of these types of deals is that they are okay with taking the property subject to the mortgage in the case where the mortgage lender is in number one position compared to the HOA. So they will take that property subject to the mortgage, knowing fully well that they're not obligated to pay on the mortgage payment. So the third party buyer is not personally obligated to pay on the mortgage payments, because remember, the third party buyer did not sign any documents with my mortgage lender. So they don't have any obligation to pay the money. The only thing the mortgage lender can do is do a foreclosure. And most of the investors, third party buyers, they already have a strategy in place where they purchase the property for like $25,000 like I described right now, and that property is typically worth about $300,000. So they would then have a tenant in there paying them, and it takes the mortgage lenders a while to come back and actually do a foreclosure. So the strategy that some of the investors have when they're third-party buyers of these types of HOA foreclosures is that they realize that they don't have to pay any mortgage payments because they're not obligated to, and so they either move a tenant in there and create cash flow, or they might actually turn around and sell that property and pay off the mortgage, because the property value might be higher than the amount of the mortgage that I still owe on that mortgage loan. So that's the way that people make it work, but you have to make sure you understand what you're getting into at the onset before you start showing up at the auction and purchasing it. And you have to realize that there's a small risk that the lender can still do a foreclosure if you took it subject to. If the mortgage lender is, of course, a junior lien holder compared to the HOA's lien, then you don't have to worry about that, because you as a third-party buyer would be purchasing it outright. And then, of course, for the people that are in the overage business, you need to know all of these kinds of stuff, because you can then figure out whether it's worth pursuing the excess proceeds. If there's a mortgage in the background, it depends, because if the mortgage lender is a senior lien holder, then they cannot go after the excess proceeds. They can only go after the excess proceeds if they're considered as junior lien holders when compared to the HOA's lien. All right, so I know it's been a mouthful and I've covered a lot of ground in a short video, and it's kind of difficult to compress all these things and make all the information very easy to digest, but I hope I've succeeded in at least helping you see that there are many layers to things, and things aren't always as they seem at first glance. So thank you as always for watching, and if you like what you're seeing on our channel, remember to hit the subscribe button so that you can continue to get video notifications, and we'll continue to put out good content for you. And of course, always let us know what you'd like us to discuss on the channel. Thank you, and I'll talk to you next time.